Now I'm going to go ahead and make you the host.
All right.
Recording in progress.
See that okay?
Yes, sir.
All right, perfect.
Hey, folks, we're going to get started here in about 2 minutes. Nick Smith with the Real Estate Commission is with us, and he's going to be doing a short presentation, and then he's going to be taking your questions afterwards. So I hope you came ready with some questions, and I look forward to hearing what Nick's got to say. So, Nick, you can kick it off in a couple of minutes if you don't mind.
Perfect. Yeah, sounds good.
All right.
Recording in progress.
Make sure you're muting yourself. Sorry, Nick, I had to go in and mute everybody. I think it worked.
No, that's okay. That stuff happens in the new world we're living in.
Yeah, I know.
Yeah. Prior to COVID, we would go present So it was always nice to go out and meet people and meet brokers and, get to put a real face on the commission. But the good part about the Zoom meetings too is I think we can reach a lot more people a lot more easily. So that is a good feature of it.
Do you want to go ahead and get started? It's all yours, my friend.
Yeah, absolutely. Hi, everyone. My name is Nick Smith. I'm a consumer protection officer with the North Carolina Real Estate Commission. I'm so glad to be here to talk to you all today. Chris, thanks so much for inviting me. Today, we're going to talk about agents' duties of disclosure. This is one of the most fundamental yet important aspects of real estate brokerage, and why it's such an important topic to talk about. I hope that I can share some of my perspective with you from working at the commission, how we view an agent's duty to disclose, and how that can help you in your practice, not only to avoid getting in trouble, but to be a better agent, so that you can be better serving your clients. As a consumer protection officer, my main job function is to investigate complaints that the commission gets. I've been with the commission for about 4 years now. I really enjoy doing what I do. Prior to working at the commission, I was a commercial broker in the Triangle. And prior to that, I worked for a commercial property management firm and development firm in Southern California, where I went to school. So I hope my experience can offer you something that you can apply in your brokerage today that can be helpful. I really welcome questions. I really want to offer everything I can to be a resource to you. So anytime throughout this presentation, please feel free to unmute yourself, chime in. More than happy to hear what you have to say, questions, comments. Also, you can type something in the chat. I'll check it periodically to make sure I don't miss anything. And with that, we'll get going. So, big thing, right? How to stay out of real estate jail. As far as it relates to disclosure, there's a few things with disclosure we're going to look at. Those being, first, we're going to review the minimum disclosure requirements that we have. So that's required documentation, things that you need to disclose to your clients, and primarily material facts. And then at the end, we're going to examine a case study that I think is very relevant to kind of wrap all of this together. And when we're doing that, you're going to get a look into kind of how we look at these complaints and cases that we get, so that you can understand how, when we see something, how you may or may not be disciplined for it. So I hope that gives you an idea of how we work a little bit. Okay. So looking at first, just reviewing these important disclosure documents that we have. I'm not going to focus on these for a long time. I just want to make sure that I brush up on them so that they're reviewed, because these are fundamental things that need to happen, as just kind of a baseline. We get less complaints about these issues specifically, so that's why I'm only going to touch on it briefly, but they are very important. So firstly is the working with real estate agents disclosure, required in all sales transactions, must be provided to buyers and sellers at first substantial contact. We consider first substantial contact when any confidential information is shared, any information that will be shared that could give an unfair advantage to another party. With that, you're thinking price, terms, and motivation. So you want to make sure that when a conversation with a buyer or seller client becomes substantial, that you use that disclosure immediately, so that it protects them, and not only protects them, but helps them understand a little bit better about what you do and what services you offer. Next, in your residential sales transactions, we're going to have the Residential Property and Owners Association disclosure statement, and the mineral oil and gas rights disclosure statements. Again, these are going to be required in all your residential transactions. Very important because they have statutory requirements for the buyers and sellers, and gives them certain rights and responsibilities in their transaction. For instance, if you're representing a seller and they don't provide a property disclosure statement, a buyer may have a right to terminate a contract that they enter within a period of 3 days. As a buyer's agent, important to get these things for your buyer clients, so that they can understand and learn of any possible defects, things that may impact their decision whether or not to purchase property. One that is less common but somewhat prevalent, and just should be mentioned, is subdivision street disclosure. Anytime where there's a new subdivision created and there will be an addition or a name change to a street, that street will need to be disclosed, whether it will be public or private, and a disclosure will need to be made. So if you're working with a seller client who may be parceling, subdividing some parcels or a parcel, and plans on developing some streets, that's something you would need to ensure that you disclose. And also the lead-based paint disclosure. So that's for any sales or lease of property built prior to 1978. Gonna have to have a disclosure whether the seller knows anything about lead paint at the property, has done any work related to lead-based paint, and then provide the prospective buyer or lessee EPA pamphlet on lead-based paint. Again, we don't commonly get issues with that. I think it's been covered in so many ways and seen so often, and fortunately is not much of an issue in this day and age. But just because of the seriousness of possible side effects from lead-based paint, it's important to make sure that you disclose. Anyone have any questions about those? Okay. And with that, I'm going to move on to talking about discovering and disclosing material facts. This will be the main focus of what I'm going to talk about today, because that is the most common complaint that we get at the commission. So we get about, right now we're getting about 2,000 complaints a year. The vast majority of them are residential complaints and the residential sales complaints. And the most common complaint that we get is a misrepresentation or an omission of a material fact. And that's pretty broad, but it's a pretty significant number. So with regards to disclosure, this is probably the most important thing that you need to consider in your practice and how you are performing your duties as a broker, not only to your clients, but any interested parties that you come across. So first, what is a material fact? It's any information that would affect a reasonable person's decision whether to buy, sell, or lease. So that would be facts about the property itself, facts that relate directly to the property, facts that relate to one of the parties' ability to complete the transaction, and any facts of special importance to a party. For example, if somebody wanted to, a buyer was looking to purchase property, but they didn't want any restrictive covenants, that would be a fact of special importance to them. So just very minimal some examples of material facts. Firstly, square footage, septic permits. We get a lot of misrepresentations or omissions regarding septic systems. So misrepresentation would be a false statement that a property, is on city sewer when in fact it's on a septic system. That's an issue because a septic system requires maintenance, whereas the city sewer system wouldn't. So if somebody is considering purchasing a property and they think they're buying a property that's hooked up to city sewer that they won't have to maintain, and then they're not actually maintaining the property, that can have some serious consequences to that system, which in turn could be pretty costly. Title issues. So, an example of that is, if you're listing a property and the seller becomes so far on their payments that notice of foreclosure is filed, that's going to affect their ability to complete the transaction. Like I'd mentioned, a fact of special importance, restrictive covenants. Those are going to be your private land use limitations that would restrict what someone is able to do on the property. So that's certainly important to know. And then facts about the property itself, property defects. That's going to be the most common one, probably. Do you have leaky roof, leaky pipes? As you can imagine, the number of possible defects are immense. What are some other ones that you guys can think of? Let me hear from some of you.
Access to a main water line if they're already on, if they're on well and septic, and someone says that there's a water line, you better make sure there actually is a water line.
Absolutely, that's great. Thank you. What else?
The limitations.
Go ahead, Dale. Sorry.
That's all right. I was just going to say the limitations to your septic permit, like it's a three bedroom and you're wanting it to be a 4-bedroom, that type of work.
Yeah, thank you, Dale. That's a fantastic example. Something we see pretty regularly with some of the misrepresentation cases that we have. What Dale was saying was, if there's a septic permit for a property that's on a septic system, say it's only approved for 3 bedrooms, and the dwelling appears to have 4 bedrooms, and a broker advertises it as a 4-bedroom. Basically, what they're implying is that the property can handle more occupants, and in turn, the system can handle more use. If a system is regularly used more than it's approved to be used for, that can damage the system long term. So that's why we would consider that misrepresentation. Great. What else?
Hey, Nick, I have a question.
Sure, go ahead.
So I had a listing one time and the sellers made an insurance claim because it had previously had a water leak and they had to have the whole floor replaced. And I didn't know that. And then the buyer, I guess, was seeking an insurance quote. And then that was brought to my attention. Is that something that we should start asking our sellers if they have made an insurance claim on their property? Because it seems to be affecting the buyer's ability sometimes to get the home insurance.
Thanks for your question, Paula. That's a really good question. So there's a few things that are good to know from having that happen and having a conversation with your seller about it. I wouldn't say in every case you would need to ask specifically if they filed insurance claims. It wouldn't hurt to ask, just because if you learn of any information, possible serious damage to the property previously, it would be good to know. So if something happens to a property, say for instance, a first floor flooded, like in that example, as long as everything is fixed properly and renovated properly, that wouldn't necessarily be a material fact that would need to be disclosed. As a listing agent, you'd want to make sure that the work has actually been completed satisfactorily and that you can, represent that it's in a good condition. Certainly always safer if you know that information to disclose it to any interested parties so they can do further research. Specifically with insurance, if a buyer is having trouble getting insurance or the rate is significantly higher, if you learn that as a listing agent, then that we may consider that a material fact because it would affect someone's decision whether or not to buy the property. We wouldn't expect you necessarily to reasonably know that until a buyer would go through that process. That being said, if you learn that information and say that first buyer didn't end up buying the property, and they would have significantly higher insurance costs because of the past issue, then that would be something you'd want to disclose. Does that answer your question, Paula?
Yes, thank you.
Okay. Yeah. Thank you for your question. Yeah.
Nick, one I was going to bring up is right of ways, road work. We have all kinds. I'm sure you do in Raleigh have all kinds of road construction going on and road projects planned. So how's that going to affect property owners? Are they going to take, X number of feet of your front yard or things like that?
Absolutely. That's one, certainly, I'm sure in your areas as well as ours that we're seeing, that would be a fact that would not relate to the property itself, but would relate directly to the property because it would still impact the property. So you're looking at things surrounding the property like zoning changes, road changes, anything like that. So as a best practice, you want to, know what's going on in your community. If there's any proposed plans like that, you can always call, call the county, city, or DOT if you want to follow up and learn more about projects, or just to check if there are any projects in the area. Any other questions?
I think I have one.
Yeah, go for it.
Let's say you're a real estate agent. Let's say you're looking for a property, okay, and you're looking to buy something.
Okay.
But you see somebody that has it as a for sale by owner somewhere, and you realize that the house is a lot less than what the market dictates.
Mhm.
What is your responsibility as a real estate agent if you don't represent that person?
Rick, thanks for your question. Yeah, so you're saying you're a real estate agent, you're looking to buy a property for yourself. You find a for sale by owner that's selling their property, and their property is what they're offering is undervalued. We don't have a specific rule that requires a broker to disclose that they are a broker in the sale or purchase of their own property. We highly recommend that you do, first and foremost, because if you don't disclose it and the person you're dealing with later finds out, they will probably think there's other things you haven't told them, and there will be a kind of a perception issue, and they may file a complaint because of that. That being said, if you're going to approach someone to buy their property, and they don't have a representative, we strongly recommend that you do say you're a broker, that you recommend that they consider hiring their own broker or attorney to represent them, and that you're not going to represent them in any capacity. Doing that in writing is the best way so that you can prove it. But if you're not representing them, you don't have a responsibility to advise them about the price.
Hey, Nick, can I piggyback off of your statement, please? So, Rick, it's a code of ethics that we are under, that we do have to disclose that we are an agent.
Mm-hmm.
It might not be a real estate rule, but it is one of our code of ethics.
Yeah, so if you're a realtor, then yes, from what I understand, it is part of the code of ethics. So you would still want to do that. Thank you for mentioning that. Sometimes I do forget to mention that. So yeah, we don't at the commission, we license and regulate all brokers in the state, and regulate them using the real estate license law and our commission's rules. So if someone chooses to be a realtor, then they are also choosing to abide by that code of ethic, and that is one of them that you would need to disclose that you're a broker in any transaction. Thank you. Well, I'm gonna keep the slides moving. I just have a few left. Certainly welcome any more questions, comments, and want to get to a case study that we have that I think will be kind of good at wrapping up a lot of these issues that we see. So I'm going to go ahead and skip this example because that's the case I'm going to talk about. So just briefly going to go over what some listing agent duties to disclose are. You're going to want to explain to sellers that your firm is required to disclose all material facts pertaining to the property about what you know or should reasonably know. That's going to be in your agency agreements typically if you're using a standard form agency agreement. But that's something you want to reiterate. A lot of the time we're seeing in today's seller market that sellers are really trying to cover up or minimize some issues that they're having because they think they can get a buyer under contract immediately and not have to disclose anything. They still need to understand that you as a broker have that duty. So for things where as far as sellers being truthful as well, some sellers will say that they have renovated certain things when they haven't. So if a seller is listing updates that they've done to the property, it's always good to ask for some evidence that those things happened, of when specifically they happened. They might not remember the actual year that something happened if it's been a couple of years. I know I have trouble remembering what I did last week. So it makes it really hard to remember, when I replaced my water heater. if it was a few years ago. So anytime you're considering making a representation about when something was renovated or replaced, having some type of documentation that actually shows that is really helpful. That's going to help you be more accurate and honest in your advertising. Want to try and avoid relying on previous listings for information because that information isn't always accurate. Not a bad idea to look at previous listings to see if there's any information that may be helpful. However, if you rely that, you know, a previous listing said something was city sewer, you know, and just pass that right along into your listing without actually calling the environmental health department to see if there's a septic permit or anything like that, that can land you in some trouble. Want to make sure when you do a walkthrough, you're looking at the property, see if there's any red flags. Is there any staining on the floor, on the ceilings? Are there any cracks? Anything that would give you pause if you're looking at it in the eyes of a buyer and you're considering, say you're considering buying the property, you know, are there some issues that you would want to know about? Is that a possible issue? And if you see any of those red flags, encourage your sellers to look into it, allow you to hire people to look into it, whatever it may be, to get a better idea of what it is. Because you don't want those issues to unexpectedly pop up later and you know, cause issues in the middle of the transaction when there's already money on the table and things happening. So other things to do, you know, if you're talking to a seller and they said they've added on or renovated part of the property, check and see if there's permits for the renovations. That's an issue that we're seeing more commonly now is brokers not disclosing unpermitted renovations, which can prove costly to a future buyer. If there's any code violations, and not only costly, it can be a safety issue. You know, so important things to look into. As a buyer's agent, you want to ask the questions that they may not know to ask, look into the things they may not know to look into that might affect their decision whether to buy the property or not. Take careful consideration into what their needs are. If somebody does say, I want to buy a property where I can have chickens, are you seeing if there's any restrictive covenants, any local ordinances that would prevent allowing chickens? We've had some cases about that. You know, it's if someone, another one we see fairly regularly would be if someone has an RV and they want to be able to park their RV on the property. Is that something that an HOA would allow? You know, if they have a boat and it's a lake community, are they able to dock their boat? Is their boat too big? There's all types of factors. We don't have a list of everything. You gotta really look at, you know, what your buyers are looking for and what questions you need to ask and things you need to understand for them to make a good purchase. Do as much as you can before making an offer. That's not always possible in today's market. So at least once you're under contract, making sure you can verify all that information, so that at a minimum, before your buyer makes a decision to complete the purchase, they can know everything they can about the property first. One of the things I highly recommend that you do is to, if there is an HOA, to actually contact the HOA, to get financial documents, to get the bylaws, to get codes, covenants, and restrictions for your buyer clients, to see if there's anything that would impact them. Ask if there's any special assessments, things coming up. You know, we're seeing cases where people will purchase in a HOA community with the intent to rent the property, not actually live in the property. And then there's rental restrictions. So someone working with an agent is saying, I want to buy a property for rental, and then they end up buying a rental in a community that doesn't allow rentals. That's, you know, that's one example of what it may be, that you would need to do some legwork and see, you know, is this possible for them at this property? Can they rent this property? Any other thoughts on things that you do, or things that you recommend other brokers do? Well, the list is exhaustive, and without specific things you're looking at, I can understand the hesitancy to say, but what I'm trying to convey is that each transaction is different, each set of clients is different, and their needs are different. But you always still have that same duty to discover and disclose. So ask more questions, do everything you can to learn as much as you can about a property, so that you can provide the most information that you can to your clients, so that they can make the best decisions they can make regarding their transactions. So quick case example that I have, where this was a multiple listing agent's failure, a buyer's agent's failure, regarding a septic tank. So complaining witness filed a complaint because she purchased a property 2 years after her toilets and tub backed up with sewage. Listing broker had represented that the property was on city sewer and that it wasn't actually on the septic system. So the buyer bought the property thinking that it was hooked up to the city, and the listing broker relied on the previous 2 listings that also showed it was city sewer. They also said that, you know, it was in the city limits in the neighborhood. Didn't say there were any red flags as to why it wouldn't be. It turned out that in that neighborhood, the neighborhood was built in the 80s. And in the early 2000s, the city went in and offered to provide city sewer to those properties that all had septic, but it would cost each homeowner to hook into the system. So rather than requiring all of them to do it, they gave them the option to do it. So some of them actually were hooked up and some of them weren't. So the property in this case actually wasn't ever hooked up. And ultimately, you know, the buyer's agent didn't question it. And the buyer, as a requirement for their purchase, wanted a property that was on city sewer because they had had issues with the septic system before. What do you guys think the outcome of the case was? Anyone want to take a stab at it? I know there wasn't too much detail, but what do you think?
I believe that either the buying agent or the selling agent probably had to pay to get the house connected to the city sewer.
Okay.
Yeah.
Yep.
I was gonna say the same thing, but I was gonna say they probably split it between the two of them.
What about the prior agents, the two listing agents before? They still made a misrepresentation, right?
Was it longer than 3 years, or does that matter?
Doesn't matter. So, and that's a good thing to point out. So we require brokers keep records for a period of 3 years. But there is no statute of limitations with us on a complaint or one of our investigations. So in this case, I think the transaction was completed in 2020. The first two sales took place in 2016 and 2017. Any other thoughts?
I have a question related to this.
Okay. How about this? I'll say what happened and then you can ask your question. Does that work, Rick?
Sure.
Okay. So in this case, the listing agent, the most recent listing agent had errors and omissions insurance. They filed a claim with their errors and omissions insurance. It covered the bill for the homeowner to hook up to city sewer, which ended up costing close to $28,000 because they also had to pipe to the house. So it wasn't just the hookup, it was actually installing the system to the house. So because there was that resolution, the listing agent was required to take the issues and answers course. The previous listing agents were both respondents in the case. They had to take the issues and answers course. And the buyer's agent also had to take the issues and answers course. So there was no suspensions or revocations or anything like that. Ultimately, the buyer was made whole. Had there not been a resolution with the insurance, that may have changed how the commission would feel about it. But I can't say for sure because that's not how it happened. So yeah, that's how that one ended up. What was your question, Rick?
Okay, I live in a subdivision, so I'm on, city water, city sewer, and I keep getting a letter in the mail about insurance for the pipes outside of my home going into the city, trying to get me to get insurance for these pipes. If they break, they're my responsibility, blah, blah, blah. What kind of information are we supposed to provide to a potential buyer about something like that?
That's not information you would have to provide. I know when I bought my house, I started getting a lot of those as well. It's something you can provide to them anytime you're talking about systems that are expensive. If they malfunction, getting insurance is not a bad idea, but of course that costs. We're not going to say you have an active duty to tell your buyer clients that they need to get this insurance to cover their lines from their house to the city system. Same as with a home warranty. We're not going to require that you say, oh, you should get a home warranty. But getting a home warranty is not always a bad idea. It can, for a smaller fee can cover some pretty expensive systems. So yeah, anytime you can provide more information to your clients about options available to them, it never hurts. Yep. Hope that answers that. Yeah,
Thanks,
you're
man.
welcome. Absolutely.
Also, back to the first part. What type of insurance did you say? Who had the insurance, and what type of insurance did you say they had for the completion of that $28,000 project?
It was errors and omissions insurance for the real estate broker, the listing firm. So that insurance protects a broker's liability for mistakes such as this, where he had made a misrepresentation that had led to damage to someone who bought the property. certainly a consideration in your business to have it if you don't. I don't know too much about it as far as costs and things like that, but something you can talk to your BIC about if you're interested. Any other questions, comments about this case? Okay. So just some takeaways from this part of the presentation. I know it was kind of a cursory review and pretty general, but hope that it reiterated some things of importance and were some good reminders for your practice, and maybe some things you hadn't thought about that you can apply in your practice. Just big takeaways: make sure you're doing your due diligence to discover and disclose material facts, that you're taking the time to go over those minimum disclosures with your clients and your transactions. Generally speaking, it's always safer to disclose, and it's always safer to disclose in writing. That way you have proof of a disclosure. We don't often discipline people for disclosing too much. I don't know if we have. So disclosure is always safer. And something I like to point out too is one of the newer brochures that we have is questions and answers brochure on buyers' due diligence. I think it's a really helpful brochure to give to buyers, particularly first-time buyers. It can help them understand things they may want to consider, services they may want to consider when they're buying property. They can help them, make some of those decisions on what to look into when they're considering purchasing property. Otherwise, we have lots of brochures and publications that are helpful, that can help your clients understand things a little better, like earnest money deposits, due diligence fees, questions and answers on home inspections. Using the brochures isn't required. I like to promote it because it's helpful information. And it's always good to provide more information to your clients so they can make some informed decisions.
Hey, Nick, I have a question for you.
Of course.
So recently I was representing the seller on a transaction, and they completed the disclosure form, and I explained that they need to be honest, they need to know everything. There were some things that afterwards that they did not disclose that was discovered. But I guess my question is, during my due diligence of discovering these things, and I go to the seller and say, hey, this was, like, for instance, there was a small fire in one of the rooms. It was noted on the tax card, and it had been repaired. They didn't have any invoices for the repair, but they didn't want to. How should that have been disclosed? If they didn't want to update, if the seller doesn't want to update the disclosure, it as the agent, how should I have handled that?
Sheila, that's a really good question and a really good example of a real world situation. And maybe your seller doesn't want you to disclose it too. That's why it's really important to remind them that you have a duty to disclose, and that you are going to disclose any material facts. If you don't know for sure that those repairs were completed satisfactorily, my recommendation would be to disclose to the buyers or their agent of that, and point out that it's noted on the tax card. That way they at least know if they want to do some additional digging, they can. That I think you know, the worst thing would be is if the seller, not the worst thing, but if the seller had fixed everything properly and there were no issues, there's not going to be anything coming from you disclosing that to the buyers. So.
Okay, so in other words, I mean, I can't update the disclosure. So in other words, I would put it in like on MLS and the agent comments,
Yeah.
and then
yeah.
attach the appropriate documents of whatever I have. Okay.
Right. Yeah. Because you can't change the disclosure. Of course, if they, you know, if you learn something where the seller completes the disclosure statement, they can check yes, no, or no representation. In any instance where they check no and they actually know there's a defect, you should advise them to update it to either yes or no representation. They can choose no representation if they know about a defect and just choose not to disclose it. It limits their liability. If they check no and know about a defect, it may open them up to some liability. You know, and if they do say yes, and they can explain what that issue is, then that would limit their liability as well. So you can always revisit the property disclosure statement if there's anything that you or the seller learn that would prompt a change on there or should prompt a change on there. You should definitely bring it to their attention.
Okay.
Does that answer your question?
Yes, it does.
Okay, good.
I have a question, Nick.
Yeah, of course.
Say there was a house fire years ago and the seller has made all the repairs, had everything permitted, everything is great now. They don't need to disclose that on the property disclosures if everything is in working condition currently, right?
Right. Right.
Now, as a listing agent, should I disclose that there was a fire previously, but everything has been repaired accordingly?
I would recommend that you do. You don't have to if everything's been repaired. And it would come down in your confidence in that everything was actually repaired completely and satisfactorily. So permits are a big part of that. You know, it's one of those things too, as a buyer, you know, no one wants to hear that a house you're considering buying was possibly on fire before. So there might be some hesitancy to disclose it. I can understand that. You're trying to sell the property. However, if there is a latent defect or something that might be covered up that wasn't adequately fixed, that opens up a little bit of liability to you if it's something you knew about and you didn't disclose. So that's why I kind of say it's always safer to disclose, share everything that you know about it, and then let that buyer make the decision.
Okay, so again, the seller can go ahead and put no defect, but as the listing agent, I should maybe even in agent remarks, put a note in there about what happened and what repairs were made.
Right.
To cover myself.
Okay. Yeah, it'd be putting the buyer's agent on notice.
Okay.
That
thank you.
This is something they may want to look into further, just to make sure they're doing their due diligence.
Okay, thank you. I appreciate it.
Yeah, you're welcome.
Hey, Nick, I have a question.
Yes, please.
In a renovated home, I am the buyer agent, and there is no permit for the electrical panels outside the property, and the seal is broken. The buyer accepts the situation as is. The listing agent said it was cosmetic repair. So what can I do, me as a buyer agent, to accept the situation as it is, if the buyer saying it's okay as it is?
So let me just make sure I have your question right. You said that the electrical panel was not permitted?
Yeah, if the listing agent say it's not permitted because it's a cosmetic repair and the buyers want to accept it as it is, what should I do?
Typically, anytime that there's an electrical, gas, or structural repair, that's going to require a permit to get repaired. So I would call the local building department in the county where the property is located and ask, you know, if an electrical panel is replaced, what permits would need to be pulled. That way, you know, if there should be one for sure. And if not, and if there isn't one and there should be one, that your buyer understands that. And if they're okay with that, that's their decision. You know, ultimately, they're the one buying the property. Your duty is to disclose so they can make an informed decision. If that doesn't bother them, that's fine. You know, it would bother me, but I'm not that buyer. So I think as much information you can find out about the panels, if it was done properly, would be the best that you can do. And you can always recommend, if they haven't had an electrician, come look at it.
All right, thank you.
Yeah, if it's one of those things where it's not permitted and it's a possible issue, maybe it was noted on the inspection report, it's always a good idea to evaluate it further if a qualified professional would be needed. So
All right, thank you.
yeah, you're welcome. Absolutely, good question. These have all been great questions. I really appreciate it, guys.
Hey, Nick, got
Yeah.
a quick one for you.
Sure.
May not be quick. So recently I heard of Concord Regional Airport has a master plan, and that master plan includes expansion, which includes, looks like an eminent domain of a couple of developments that are adjacent to the airport.
Okay.
I didn't know an airport had that power, but evidently they do. And so the neighbors, we had some folks buy a house and they were talking to their neighbors, and that, of course, that's how you find out everything. And they found out that their homes were going to be taken by the airport. The sellers said they didn't have anything on it. They heard about it, but it's one of those things that's been going on for like 10, 15 years talking about it. And now evidently it's coming to fruition. I think the sellers, from what I've heard, were a little deceptive in telling the agents that they didn't have any. They didn't mention it until after the fact, after they had sold the home. Would an agent have any duties there to disclose? Because the only way an agent, the agent found out was contacting the airport.
Yeah, that's a difficult one, because it sounds like from the way that you described it, it's here's a fun pun. It's been up in the air, you know, for a long time and not certain. Still, if there's a rumor, a rumbling, you know, if it's discussed in town meetings, if it's advertised, not advertised, but if it's put out in local news, if you're doing business in that area, it's probably something you should know about. You know, and if we're looking at a complaint because of that, we would want to get more detail than what you described. I can't say specifically, but you, as a broker, you want to know what's going on in your local community where you're doing business, so that if there are any issues like that, even if they're just proposed, that it's brought to the attention of any interested parties. So I hate to say I don't have a definite answer for you. but probably some signs there that maybe it should have been known and disclosed. If it's a buyer, that's other things to think about. So say if it's someone in the same community just moving to a different house in that community, they probably knew about it already.
Yeah, I
someone
would
from
imagine the sellers got something in writing in the mail. They just never disclosed it.
Right.
But so, I mean, honestly, the buyer's agent, the seller's agent, and any agent that had sold property in that neighborhood recently would probably have some kind of liability. Would you agree with that?
It's certainly possible. But again, I wouldn't be too sure without really looking into it. Yeah, we certainly come across situations where sellers don't disclose things that they may know about, and
Right.
and we're looking at the lens of discovering and disclosing material facts that you reasonably should know. So what information was available to you that would allow you to reasonably know? One of those things where a seller is being untruthful could discount from what you would be able to know, because it's hard to know if they were the only ones that know about it.
Right.
If that makes sense.
Hey, one more question for you.
Sure.
Speaking of disclosure, we have a form that we use called an affiliated business disclosure.
Mm-hmm.
Is that some kind of material fact that we have to use? Is that just a, best practice, or is that a requirement from your perspective?
So an affiliated business disclosure is typically used to, the general purpose of that disclosure would be to let a client know that other businesses that are providing services to them have an affiliation they're related to or shared in some way. So what the purpose from a license law standpoint is that any compensation coming to you or your firm is disclosed to that client. So if you're recommending a service to them where you might get a kickback, or you might get another stream of income, Commission Rule 109 would require you to disclose that in writing. So if you're, this isn't common, but I'm having trouble thinking one off the top of my head. Say if you're a broker, your firm owns an inspection company and you recommend the inspection company. So your firm will earn money from recommending that inspection company, or not from recommending them if that client uses that inspection company. So if the client pays that inspection company, money in a way is going to the same people at the firm. So that would need to be disclosed. Does that make sense?
Yeah. So if we're getting a direct benefit from a client using that service, we would need to disclose that.
Absolutely. Yeah.
But if a client doesn't use them, there's no benefit, then we would not need to disclose that. That makes.
Yeah. If you're, well, from a license law standpoint.
But not RESPA.
Well, we allow vendors to market to our agents.
Okay.
But that's not tied to a transaction in any way. There's no benefit in that way. So I guess my question is, would we need to disclose that?
I wouldn't say just if you're letting them advertise. If you're getting, are you getting compensated for it?
No.
No.
It's just a
no.
right to advertise to those folks.
Yeah, then no. Yeah, look at Commission Rule 109.
Okay.
And consider it with your disclosures and how you do it.
Okay.
You know, but the main thing with Rule 109 is that you're getting compensated. So if you're not actually getting any compensation, then it wouldn't be an issue.
Okay.
Yep.
Thank you.
Mhm.
Hey, Nick, I have a question that there is a firm, a local firm that every time, like, they are the buyer's agent.
Mhm.
And every time that they close on a home, they go back and they put their sign in the yard with sold. I know that is a violation of a code of ethics. Is that a violation from the North Carolina Real Estate Commission stance?
The short of it would be no.
Okay.
So long as they're not implying that they actually listed the property.
Hmm.
Because if they were involved in a transaction as a buyer's agent, they helped the property get sold and actually were involved in the transaction, got permission from the new owner to place the sign. Rule 105 would require that you have permission to put the yard sign in. Then as long as you're not misrepresenting that you listed it, then we wouldn't have an issue with it, because it's truthful if they help sell it. If they're implying that they listed it, that's where the problem would be, because it would be false advertising. Yeah, I've heard that coming up a little bit more. You know, with as tight as the market has come to be, with low inventory, people are getting a little more creative in ways to advertise and market. So we're hearing about things.
It's happened to me a couple times on my listings, and then I have people calling me. They're like, "Oh my gosh, did you lose the listing?" And I'm like, "No, it's sold."
Right.
And they're like, "Oh, because we see another sign out there with the word sold on it."
Right. Yeah, and I wouldn't say that if they were involved in the transaction, I think sold is fair. I don't think it's implying that they listed it. That would be where the main issue would be, is if they're misrepresenting.
Hey, Nick, I don't want to hold you up, but do you have time maybe for one more question from one of our agents?
Yeah,
Question.
absolutely.
I've got
All
a
right,
question.
Connor, go ahead.
Got a seller who has a inherited house that needs repair. Seller doesn't have the funds to do the repair. If me as a selling agent would foot them the funds to do the repair, is that a commingling problem?
No, you would want to have it, if you're okay with doing that, you would want to make sure you get it in writing.
Got it. Get a lawyer to draw it up first.
Yeah, that would be the best thing you can do. But no, if that's something you want to do, then that would be fine, as long as you have it writing.
And the compensation, do I work that out with the lawyer on the front end and do the commission on the back end, or can it be tied to the commission at the closing?
I would think it could be at the closing.
Okay.
Yeah. I don't, yeah, because typically with a typical agency agreement, you're going to get paid at closing.
Got it.
So I don't think you'd be getting paid before closing, and that might pose an issue with it actually happening. And if there's a lender involved, if they have any issue with it, it's on the seller's side. So I don't think that would be an issue. And with it being on the disclosure, I don't see how it would be an issue either. So long as it was all sorted out before the completion of the transaction.
Thank you.
You're welcome. Yeah, well, y'all have been great with all the questions. I certainly appreciate it. It definitely makes it a little more lively, and I think a little more helpful getting specific questions. I do have a few more minutes if you guys have some more.
Well, Nick, if before anybody talks, I do appreciate you coming on with us, and I'd love to have you back for another session if possible.
Of course. Yeah, thanks so much, Chris. I really appreciate it.
Thank you. Yeah.
It's always nice to branch out and get to talk to brokers in this way rather than investigating cases. It's good.
You know, I usually hesitate to answer a call with the Raleigh area code, but because of that, but putting a face to a name helps a ton to get to know people up there, and helps us realize that you guys are there to help us as well, not to beat us over the head with the rule book.
Yeah, and I certainly appreciate that. I understand that. I was even when I was applying to work here, I was a little nervous about even doing that. But you know, we want to be a resource to y'all. We want to help you any way that we can. You can call the Regulatory Affairs Department with questions that you have, transactions you're dealing with, things like that. If you're having difficulty understanding a law or a rule or anything like that, feel free to give us a call. Always happy to help. We have 2 dedicated staff information officers that just answer calls from brokers and consumers all day, and can help you when you're in those sticky situations. Yeah, we try to take an educational approach rather than a punitive approach. So we try to elevate everyone to a higher level rather than, like you said, Chris, just beat you on the head with a rule book. You know, occasionally that happens as a regulatory body, but we really want everyone to flourish and do it the right way. That's what we really want. So please feel free to use our resources, go on our website, check out what we have to offer. It's a lot of helpful information, bulletin articles, things like that. And feel free to give us a call anytime.
Awesome. Thank you, sir. I guess that's it. Nick, again, thank you so much. And folks, we'll have this up on our private YouTube channel, hopefully later today for you to view. So thank you very much.
You're very welcome. Thank you all again. Have a great day.
Thanks.
Thank you,
You
Nick.
too.